Hello, everyone. Welcome to tonight's SFG meeting for the mentor group. I'm going to talk about default judgment and how to accept it for value. Um, what this is again, we did a meeting last night that talked about, a different case where I accepted it for value. Whenever you get an order, remember an order is a negotiable instrument. So even if it's a judge's order, it's still a negotiable instrument. It still has value. And if you don't do anything with it, you just leave it open, right? So remember that there's three kinds of accounts. We talked about this before. There's a stated account, or there's an open account, a stated account, and a um, settled account. There's no such thing as a closed account. Okay. So when you get an order, that's an open account, right? So if you don't do anything with it, then it never becomes settled. But when you accept it for value, you settle the account, right? So I'm going to show you how I did it with this was a credit card. So it should be a little interesting. Get this open. Okay. All right. So we'll start right here. This is I'm going to send you guys this in the chat so that you have it. But what happened at law? Default judgment, no answer. Basically, I didn't answer it. I was in jail, whatever. So more than 15 days elapsed, and so they had court there, and so then it was called a default judgment, right? So you just entered it in a default judgment for the principal amount, and um, and then the court ordered the insurance of the writ against you for the $1,541, right? So what this means is a valid judgment at law now exists. The plaintiff has the judgment lien instrument. The court has exhausted its role unless properly reinvoked. Okay. What has not happened is no findings of fact, no standing assignment or proof of claim, no evidence was tested, no equitable defenses, no jury trial occurred, and no determination of ownership of the debt. Okay. So what I could do is I could file a motion to open it. Okay. I could file a motion to set aside. I could appeal it. Um, but this is what I choose to do. Now, remember yesterday when we were talking about trust, right? We were talking about reliance, right? That you have to, if you are claiming to be in equity, you got to stay in equity, right? So you don't want to go back and do these things. So in equity, the magistrate court operates strictly at law. It does not adjudicate equity. A default judgment does not bar equitable relief, right? So equity can still address standing, assignment of defects, trust estate interests, accounting, fraud of the indictment or the inducement, I don't know what that word is, failure of consideration, and constructive trust, unjust enrichment. But equity must invoke properly and in the proper form. Bottom line, at law, the default judgment was properly entered procedurally based solely on a non-response. In substance, nothing about the truth, ownership, fidelity, balance, or alleged debt was overeducated. If you want, so then the next thing is a default judgment is equity. In equity, a default judgment is not a determination of truth. It is a procedural confession by silence. Okay. Presumption arising from non-appearance. Okay. Court itself admits this by its language. No evidence was weighed. No facts were found. No issues were tried. No standing was proven. No assignment was examined. The judgment exists only because no answer was filed, not because the claim was proven. What equity recognized the judgment as, and here's where it gets important. In equity, this judgment is treated as a security instrument, not ownership of a debt, but a claim reduced to form. Okay. So equity sees it as a chosen action, a lien type claim, a security dependent on enforcement, not a title, not beneficiary ownership. Equity distinguishes sharply between judgment, a form, and right, a substance, right? So it doesn't have substance. There's no rights conveyed. What did not transfer in equity is the judgment did not convey equitable title, beneficial ownership, trust res, right of subrogation, standing as creditor in conscience, priority over superior equitable interest. And why? Because equity will not perfect what was never proven. Okay. Equity does not complete an imperfect gift. Okay. So, what equity cannot do is cure defective assignment, create standing where none had existed, convert assumption into fact, and transform silence into consent in conscience. Okay. The maxim that governs this, these are the maxims of equity. Okay. Equity regards substance rather than form. Equity will not suffer wrong to be without a remedy. In other words, so if there's a default judgment, right, and the person that the judgment is against, if they want to remedy it, they can't not accept it, right? So equity will not suffer a wrong without a remedy. So we're going to get into the remedy here in a minute. Effective silence in equity at law is default. In equity, no admission of truth, waiver, equitable rights. Uh, Silence is no admission of truth. Silence is not a waiver of equitable rights. It is not a consent to fraud, and it is not estoppel unless reliance and injury are proven. Okay? Equity only binds silence when there is a duty to speak. Silence caused determinal reliance, and conscience requires enforcement. In other words, let's just say that you're in court and the judge asks you something and it's your turn to speak and you say nothing, then that's what they're talking about, a duty to speak. If you're quiet when there's a duty to speak, then that's fraud. Okay. Equity's view of the plaintiff's position in equity, resurgent stands as the claimant with a paper judgment, not a proven creditor, not a beneficiary, not a trust, not an equitable owner. Okay. Until equity confirms valid assignment, consideration, standing, accounting, and absence of fraud, the judgment is provisional in conscience. So the judgment does not bar equity. The default judgment bars legal defenses, does not bar equitable relief. Okay. So practical equity meaning plain language. Okay. Equity treats it as evidence of a claim, not proof of entitlement, not proof of debt, not proof of authority. Why this matters going forward is because in equity, a judgment can be restrained, a judgment can be subordinated, a judgment can be set aside, a judgment can be treated as a security, and a judgment holder can be compelled to account. Okay. So in the summary here, in equity, the default judgment is a procedure shadow. It has form, but it has no conscience, no proof, no equitable title unless and until equity confirms it. Under equity doctrine, saying I have accepted for value has a very specific meaning, and it does not mean that people often assume it means at law. I'll stay precise. Okay. So, what I'm doing now, right, I'm going to show you here. So, accepted for value, right? So, here's the order and judgment, and then accepted for value, exempt from levy, blah, 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 the same thing that everybody, talks about here. All right. So that's what I did, right? So that's accepting for value, right? So we'll go back here. So inequity, acceptance for value is not payment and not satisfaction. An equitable election to treat the instrument as a charge against the issuer's claim rather than a personal obligation to the acceptor. Okay. In other words, you did three things at once in equity. You did not dishonor the instrument. This is very important. I've been teaching you guys this all along, is to not be dishonorable. You did not dishonor the instrument. You did not contest it at law. You accepted the burden conditionally, shifting it into accounting. So basically, you're saying, okay, I want the accounting, right? You're saying, I accept this security, right? And now I want the accounting, right? So once accepted for value, the judgment changes character. Before accepted for value, it's an adverse legal instrument, plaintiff claims enforcement rights, defendant positioned as obligor. After accepted for value, the instrument becomes an account item. The claimant becomes a party owing proof. The judgment is treated as a security, not ownership. The matter moves from liability to accounting. He who seeks equity must do equity. By accepting for value, you have not refused, you have invited settlement in conscience. Remember the three types of accounts. The last one is a settled account. Invited settlement in conscience. In other words, you're saying, yep, I understand that this is owed and I accept it for value. Now balance the account. Okay. So accepted for value does not mean the debt is discharged. In equity, it does not mean discharge. It does not mean satisfaction. It does not mean cancellation. It does not mean payment. Instead, accepted for value means I accept the claim subject to proof, set off reconciliation, and accounting. If someone says accepted for value automatically pays the judgment, that's not equity. Okay. Once accepted for value is properly expressed without dishonor, equity shifts the burden. The claimant must now show standing in conscience, valid assignment, consideration paid, chain of title to the claim, accurate accounting, absence of unjust enrichment. So understand here, consideration paid. What they have to do when you accept it for value is they have to turn around and they have to say, okay, this is where the consideration was paid. But they can't claim that because no consideration was paid. We already know all this stuff, right? Equity will not allow a party to collect twice, collect without proof, or retain unearned benefit. Your acceptance for value does not stop you because you did not admit truth, you did not waive equity, you did not concede ownership, you did not agree to personal liability. Equity estoppel requires representation of fact, reliance, and injury. Okay. So, acceptance for value and merger. This is the key part here. Equity doctrine of merger asks, did the obligation and the remedy merge into one and extinguish the prior relationship? Here, no merger occurs because you did not accept the judgment as final in conscience. You did not accept personal liability. You accepted it for value and accounting. Therefore, the claim remains open in equity and the judgment remains non-merged and the superior equitable interests remained intact. Okay. After accepted for value, equity sees you not as the debtor, but as a conditional acceptor, a party demanding accounting, a party holding the instrument in trust, a party preserving rights, a party preventing dishonor. You have neutrally you have neutralized hostility and shifted posture. What equity now sees the plaintiff as is a claimant holding a form, a party required to prove conscience, a party subject to accounting, a party. So, in other words, they're in limbo now because now they got to prove all this other stuff that they can't prove, right? So, if they pursued without accounting, equity treats that oppression, not enforcement. What does not protect you from automatically? Acceptable value alone does not stop levy, garnishment, execution. Those are legal processes, not equitable ones. Once a sentence equity summary. By accepting the judgment for value, you did not concede liability. You converted an adversarial claim and equitable accounting and preserved your superior rights and conscience. Where this usually goes next, not instructions, just doctrinal outcomes. Equity expects notice, equity expects accounting, equity restrains double recovery, equity prevents unjust enrichment, equity will not enforce bare paper without conscience. Okay. So now we're going to get down in here. A lot of this stuff is just going over it again. Okay. So now we're going to do a notice, right? So last night we talked about notices and so here it is, right? So here's the template. You're going to get this so that you have this so you know what you're doing, okay? So now we're going to look at the notice, right? So here's the notice that I submitted. So you already seen here that I accepted it for value, and then so notice of equitable acceptance for value and reservation of rights. This notice is given in good faith and in equity regarding the final order in default judgment entered in the Magistrate Court of Morgan County, Georgia, civil action number XYZ, resurgent receivables, assignee of Credit One Bank versus Kent Stark. Notice is hereby given that the undersigned has accepted and referred reference judgment for value without dishonor, protest, or refusal, and without admission or liability, ownership, or obligation. Such acceptance is made conditionally and in equity for the purposes of reconciliation, set off, and accounting only, and shall not be construed as an admission to the truth of the allegation, a waiver of equitable rights and defenses, a confession of liability, a merger of obligation and remedy, nor a consent of enforcement absent proof of conscience. Judgment is held in constructive trust pending lawful accounting, proof of standing, and reconciliation consistent with the equitable principles, including not limited to the prohibitions against unjust enrichment and double recovery. All rights are expressly reserved, including the rights of equity, trust, and conscience. Nothing herein shall be deemed a waiver of remedy or a submission of jurisdiction beyond what has been lawfully established. The notice is given to preserve clarity of position, maintain clean hands, and evidence readiness to do in equity. Issued without prejudice, me. So then here's the accepted for value. Here's the bill of exchange that I sent them for the payment, right? This is the cash equivalent. So here I'm accepting it for value, which is the bonded promissory note right here. Okay. Then the bill of exchange. And this is what I sent to the IRS, right? This, this, this. So a 1096 with the 1099A accepting the debt, 1096 and an OID accepting the debt for the default judgment. Then I send all these copies to the court, right? Because I'm noticing them. So now I noticed them of what I'm doing. I accepted their instrument for value. I sent them a cash equivalent, and then I submitted the accounting. That's what these documents are for. The 1099s are ledgering documents for accounting. So then I did the accounting. So this is satisfied. So I know these last two nights have been information that you really haven't like grabbed onto, but I'm trying to give you all this information so that you have it. And I'm gonna send you the notes so that you can read through it. And a lot of this stuff isn't gonna be stuff that you're gonna use right away, but understand that all this stuff that everybody's telling you to do, accept for value, accept it for value, do do this process on the stub of a power bill or whatever, right? But they're not really like explaining to you what you're doing and why you're doing it, right? And so these last two nights I've been trying to give you this stuff and show you and give you notes so that you can, at least save them so that when you get through a lot of the other stuff that you're doing and then you end up with a default judgment, you know how to handle it. You know how to be honorable, right? Because even getting a default judgment and going in and paying it is dishonor, right? The honorable thing to do is to accept it for value, and then do the accounting, right? Because if you just go and pay it, then they've been paid twice. Because the truth is, they've already been paid for the judgment. They got the money from you when you open the account. So when they get the judgment, all they're doing is they're handling their accounting. That's what they need to do so that they can keep the money. And then if you end up paying it, then all the better. Why do you think that all these credit companies pay these lawyers all kinds of money to collect money? I mean, I've had creditors come at me for $100. I know lawyers that won't even pick up the phone for less than 1,000. So how is it that $100 judgment, do you have a lawyer that gets $1,000 an hour collecting it? And the reason why is because they already got the money. They actually got 10 times that, and they loaned it to somebody else. They took your $100 and they loaned $1,000 to the next guy. And then that guy's 1,000, they loaned 10,000 to that next guy. Then that guy's 10,000, they loaned 100,000 to the next guy. right? So they don't care about your money. They're just thinking, well, maybe he's dumb enough to pay it, right? But they don't care about any of that. So this is the honorable thing to do. The honorable thing to do is to accept it for value. So um, I'll open it up for questions now. You guys feel free to ask me anything about, this stuff.
Hey Kent,
Mhm.
how did you get that default judgment? Like, how did it get to that point? Like, what were you trying to do? Know what I
Oh, it
mean?
was a credit card. I never paid it. And
Never
then,
paid, and then what? They took you to court, or they?
well, no, I submitted forms to Credit One and I paid it through the IRS through Credit One. And they're like, oh, your contract says you got to pay with Federal Reserve notes and whatever. And I was like, well, so I sent them a conditional acceptance and did all that stuff. And then I had a bunch of other stuff going on. So I never really followed up with it. And then all of a sudden I was sitting in jail and got served with a lawsuit.
From them,
Yeah,
from
from
yeah,
them. Yeah.
yeah,
And
and
then
then
and then I was incapacitated, so I couldn't go and do anything with it. So
when you got out, you did this,
yeah.
and you handed all the papers in at the same time. The notice with the accepted for value, like all
Yeah,
that.
well, first I did the IRS, and then I sent the originals, the originals of the accepted for value and all that stuff to the credit card company. And then I made copies and accepted for value and all that stuff and sent it to the court. And then I sent this notice to the court. The notice is for the court. The notice, um, this notice is just for the court. That's
Gotcha,
You don't send that to the credit card company because they don't give a shit.
gotcha. But you sent that to the court with the accepted for all the whole time. You sent all of it together.
To the court, yeah.
Yeah, to the court. Yeah.
Right. So I sent this and this. No, first I sent this and these to the IRS. Then I made copies of them and I sent this, this, and all this stuff to the credit card company. Then I made copies and I sent this and everything else to the court.
Gotcha.
Got it? Does that make sense?
Yeah, absolutely. Yes, thank you.
Yeah.
This is interesting.
Yeah, so that's how that process works. And this is administration. So once you get your living revocable trust done, then this is how you have to do this.
Okay.
Any other questions?
Yeah, so you actually, not this, but say you have another credit card. I'm not don't say how I could do it, but you could, that's why you're doing the accepted for value. You could do the same thing you did. You could send the accepted for value, your IRS forms like you did in the beginning. And
Yeah.
then if it does come down to that where you get a default judgment like you have, then you could do the other thing.
Yeah, they're
Like,
not going to take the IRS forms. I'm just going to tell you.
yeah.
You just
But
take if you're going to do it that way, you take the bill, you do the accepted for value thing on it, and then you send a copy of the bill with a bill of exchange and the IRS forms to the IRS, and then you send it back to them, but they're not going to take it,
yeah, gotcha. All right.
right? And then you're going to be in default, and then they're going to play these games. This has been 2 years
Yeah, gotcha.
before I got to this point.
Gotcha. Gotcha. Just trying to understand it a little better.
Yeah. William, you got a question?
So, kid, if you are in dishonor starting out, is there a process that while you're in dishonor, can you change to acceptance and do this process?
Yeah. So once you get the judgment, you're in dishonor. So then you accept it for value. So that's how you get into honor, right? It's the same thing if you have a criminal case and you go in front of the judge and you said, I'm not the name, but I'm here to settle all accounts for the named party. It's the same thing. You're accepting it. You're not saying, I that's not mine. Once you show up in court, you're in jurisdiction. So then you have to accept it. You have to accept it for value and then tell them to do the accounting. So that's what this is. I'm just showing you, this is just a small deal to show you how this works, but it's the same for everything. That's how you get an honor is you accept it. So as a trustee for your trust, that's what you do. Is somebody presents a debt to you or a claim, and then you accept it for honor. And then you use your IRS system to facilitate the balance of the ledger. And that's all we're doing. All we're doing is the accounting.
Gotcha.
Makes,
Thank you.
makes sense?
Kent,
Yes.
how do you know which accepted for value stamp to use on any particular document?
Whatever you want.
Because
It
there's
doesn't matter.
accepted for value and returned for value stamp. There's accepted for value and accepted for deposit stamp. There's also accepted for
So if you're
value
buying a
without.
vehicle,
Uh-huh.
right, you want to use an endorsement where they are taking that money and sending it to and through to the vehicle company. But
Mhm.
if you're doing a default judgment, you just want to accept for value the default judgment, right? But last night there was a whole different thing that I wrote on there, right? Because you want as a grantor, as a grantee, absolute, you're granting everything back to the court because you're not actually granting money, you're granting rights into equity, right? So it just depends on what you're doing, and I can help you navigate that, right? But um, the main part is the accepting for value. That what puts you in honor, and then you do the accounting, right? So
And it has to say exempt from levy?
no, it doesn't.
No.
That's just one that I use for like credit stuff, credit
And
card, things
did you
like that.
just use your printer to print at 45 degrees?
Yeah.
Or did you actually have a stamp?
No, I don't use the stamps. I use the printer.
Oh, okay. Gotcha.
Yeah, I have a little like a thing I just put in there and make a copy of it, and then I run the originals through with the copier, and it prints it with the red on it.
And does it have to be in red or in blue?
I usually do it in red.
Because I heard that the text should be in blue and your signature and name should be in red.
No,
It's no?
no, red's not contract. Blue is contract,
Mm-hmm.
right?
Yeah.
And it depends on the organization. Like the IRS makes you do everything in black,
Mm-hmm.
right? Because it's the dead, right? But I do it in red, right? And then I sign it in blue because blue is contract,
Mm-hmm. Gotcha.
right? That's just how I do it. I mean, I've never really, you're not going to get, once you do this notice with the court and everything, they're not going to say anything. They're not going to send
Mm-hmm.
you a letter and be like, oh, we're so happy that you accepted it for value. They're not going to do any of that. They don't care. They're like, okay, the accounting's done. Have a nice day.
So it's actually not going to go into equitable court. They're not going to review the case in a court of equity per
No,
se.
no, you are equity.
So what does this paper then accomplish when you send it to the court? Puts you
It,
back in honor?
yeah, it puts you back in honor, and then you do the accounting with the IRS, and then,
But Capital One or Resurgent is not going to redo their accounting and show anything that what they were doing on their end, right?
well, they're going to because it's a default judgment.
Who will they present that information to? To you or the court or the IRS?
The IRS, and they already have the money. They're just
Okay.
going to send it to the IRS and say, we're keeping the money.
Okay, so that then it becomes basically business between them and the IRS,
Right.
bypassing the court and you, right?
That's right, because when you accept it for value, you trigger the IRS to settle the account.
Oh, okay. Okay.
Now they might come back and be like, "Oh, we have a default judgment," and they're gonna, try and garnish your wages, or they may do some of that stuff. But then you just gotta. That's when you come in with your estoppel,
Hmm.
right? But
So
that's how you.
before that moment when you received the default judgment, you said that you were going through the private administrative process with them, right? With the credit one
Yeah,
or
and they
researcher.
didn't
And
care.
so you didn't actually file estoppel on them. They just filed something on
You
you.
don't file an estoppel. Estoppel occurs,
Uh-huh.
right? Like merger. You
Mm-hmm.
don't create merger. Merger occurs when you are the beneficiary and the trustee.
Mm-hmm.
Okay, so an estoppel happens when you meet the elements of it. So if you weren't here last night, watch
Mm-hmm.
last night's video I posted.
Yeah, I missed it. Yeah.
Yeah.
Mm-hmm.
So last night's video talks about that.
Okay.
So an estoppel occurs. It's not, you don't do an estoppel. So
Mm-hmm.
when you send a notice of estoppel, that's a notice. The estoppel already happened. You're just
Mm-hmm.
noticing them that estoppel has occurred,
Okay.
right?
So tonight's video is a continuation of last night's video, right?
No, this is totally different. This is accepting for value a default judgment. Last
Mm-hmm.
night was accepting for value dismissal of a name change.
Oh, okay.
So it's a
That's the letter I
whole
read.
different process, but
Mm-hmm.
it's basically the same nuts and bolts of something.
Okay.
All
That's
right.
helpful. Mm-hmm. Thank you.
Yeah. Any other questions?
I'm gonna start on that Pennsylvania name change tomorrow and
Okay.
get the paperwork I need and then get it to you, like you said, or that stuff. Just letting you know. I don't know.
Sounds good. I look forward to seeing it. All right, guys. Thanks for coming, and I really appreciate it. I did record it, so I will be posting it shortly. You'll probably see it tomorrow. And again, if after this ends, if you have any other questions, feel free to reach out to me directly, okay?
Thank you, Kent.
Yep.
Okay, thank you.
Have a good
Thank
night.
you.
See
Thank you,
y'all.
William.